Okay, so what I'm going to do as I'm grading your closed memos is talk about the issues that I found as I was grading the different distinct parts. This one's going to be relatively short. I'm sure as I go along, there will be some that will be longer. I'm going to post these as I go along. Even though we're not supposed to have any classes the week of oral reports, I may be posting some that week. These are solely to help you learn so that when you do your open memo, particularly the final one, which is worth 375 points, maybe it will keep you from making some of the same mistakes that were made this time. So we're going to get started. So first, I'm going to talk about one of my old favorites, which is following directions. And I say this because for this assignment, for the final close memo, formatting was worth 9 points. 9 points may not seem like a lot to you, but I will tell you, as someone who has been grading this class for the past 15 years, that when it comes to that final curve, 9 points can easily be the difference between a B and a B plus. Sometimes it comes down to 3 points. So to lose points on formatting, when you can take care of it before you've even written the first word, and if you take at least 15 minutes at the end when you're done writing your paper and go back over the formatting, it's not anything that anybody should be losing points from. Anyway, let's go. So these are part of your submission instructions. You will note that number D or letter D of formatting says parts of your memorandum, question presented, brief answer, facts, discussion, and conclusion must be labeled with the appropriate subtitle. Makes sense. And then it says each subtitle must be centered, bolded, underlined, and capitalized. Seems simple, right? Not so much. If you notice, the subtitles are not bold. They are underlined and all caps, but they are not bold. Points deducted. Next, single space, the memo heading, the question presented, the brief answer, all point headings, and any quotation of 50 words or longer. Double space the remainder of the memo. I'm not going to get into spacing issues when it comes to double spacing before or after titles. You'll see that on your individual paper, but you will note that it said single space the heading, the question presented, and the brief answer. And this is what we have: a single spaced heading and a double spaced question presented and brief answer. Loss of points. Then use bold print for the main heading and the subheadings. For the main heading, use all capital letters. For the subheadings, capitalize the first letter of every word in the subheading. Your headings should not be underlined. Moving on. Now we're going to talk about the memo heading itself. If you recall, these are all of the parts of your memo. We're going to talk about the first one today. Probably by the end of the week, we will talk about the next 3. But for now, we're going to talk about the first one, the heading. In the introduction to the office memorandum video from way back when, this is the memo heading that I showed you. And I told you that the heading should include to, from, date, and re for the subject. Said that the date had to be accurate because it protected you from medical malpractice. Not medical malpractice, legal malpractice. It protected you because it showed that your research was up to date up until that point. I also told you at that point in time that the subject line or the re line should include more than the client's name and file number, that it should include things like what the memo was about. If a statute was involved, it would be a good idea to include the statute name or the citation of the statute. If there was a common law doctrine, it would be a good idea to name that common law doctrine, but that it included more than just the name of the client, that it should also include a case number and other filing information. Then when I did the other parts of the memo video, I showed you the heading from the sample. And I talked specifically about how you had the client's name and the file number. And then it was followed, as you can see by green, with a brief description of what the case was about, possible promissory estoppel action. Then, as you can see in the blue highlights, it gave an indication of what each of the subsections were about. So here we have a promise and injustice elements. Seems simple, right? Well, let's look at some of your headings. So I received several of these. Read Drew Jackson and the file number. That was it. I received this one, Drew Jackson and the file number, although the file number is wrong. And it said negligence claim against Walred's drugstore. At least it's a little bit better. We know that there's a negligence action, even though the issue was really summary judgment. And we have Drew Jackson, file number, which is correct this time. Premises liability claim. I told you before I was fine with either negligence or premises liability. And then duty element. I'm not sure how helpful that is to say what the subsections were about. And pretty close. We have Drew Jackson with the file number. Likelihood of premises liability claim surviving a motion for summary judgment. It's absolutely what this case is, what this memo is about. Probably a little long. And then it says visitor status and standard of care. So you can see through the progression how much longer that reline gets when you include all the information you're supposed to include. Then just some really quick writing grammar issues. Again, spell check checks for misspelled words, doesn't check if you use a word wrong. So be careful when you're writing. There is a difference between the word your and the word your. Y-O-U''re means you are. There's a difference between to, and to. There is a difference between there, and there. The last one being something that means they are, a contraction, which you should not be using in legal writing anyway. There is a difference between it's and its. It is. Quiet and quite, than and then, whose and whose, who is, statute and statue, trial and trail, libel and liable, and any and nay. Make sure that you read carefully when you're doing your work to make sure that you are saying what you mean. And finally, some of you are still having issues on what you think courts do. So here is a list of not everything, but a lot of things that you all have stated that courts do, either in your application sections or your rule sections. Applied, argued, claimed, conceded, considered, contended, determined, examined, noted, observed, reasoned, and stipulated. Well, I can tell you for a fact that courts don't argue. Courts make ruling, they don't argue law. Courts don't claim. Once a court makes a decision, that's the court's decision. Courts don't concede. Parties concede. Courts don't contend. Again, once the court makes a decision, it makes a decision. It is not contending anything to anybody. It is stating the law. And finally, courts don't stipulate. I'm sure that you may appreciate this now that you've had to deal with your word limit, which I know many of you were struggling with. So again, let's talk about some ways you can cut your word limit down. Instead of saying a small number of, you can say a few. Instead of saying due to the fact, you can say because. Instead of saying give consideration to, you can simply say consider. In a timely manner, you can just say promptly. Reach a conclusion, you can just say conclude, end, or finish. Until such time, be shortened to until. with regard to can be shortened to concerning or regarding, and on behalf of can just be a simple for. You cut all of the times that you use these types of phrases in your writing out and used the single word, you would not have had so much trouble with your word count. On that, I hope you find this helpful. I will be giving more as I move on. The next set will be question presented in brief answer and facts. I will probably break that up because I don't want these to be too long. And I will see you all in class.